wait till. Good afternoon. Today is Wednesday, September 15, 2021. This is a meeting of the Salary Grievance Committee hearing. For item number 2, public comment, we do not have anybody signed up to speak for public comment. There will be no action for item number 2. Item number 3, Salary Grievance Committee hearing. Pursuant to Texas Local Government Code, Section 152.016, for the County of El Paso elected officials who grieved their salary for the 2021 through 22 fiscal year.
Thank you, and very special thanks for our Salary Grievance Committee. I know it's not easy to be here, but we depend so much on feedback and our public. And then Alex, I'm going to go through it. I'm going to read it very carefully and slowly because I want to make sure that everything is understood, and then any questions that you might have. But once again, knowing our times, and you could see how our world has changed, but so I thank you, because this would have been difficult even without a pandemic for you all to be here. It's not an easy task, so we really thank you for the time you're going to spend here today. I think we want to make it productive and make it as fair and make sure that you know, we get to the right decision. So I will begin to read by state law, I'm responsible to serve as the chair of the Salary Grievance Committee. I'm not voting member of the committee, so I am not a voting member, but I am here to preside over the hearing and maintain decorum and move the hearing along. So what is the salary grievance? During the budget process, the Commissioners Court holds a series of public hearings during which the Commissioner Court receives presentations from various people on different aspects of the county budget. One of the primary duties of the Commissioners Court is to adopt and manage the county budget. The Commissioners Court considers what amounts of funds should be budgeted for law enforcement, in particular the operation of the Sheriff's Department and the operation of the jail. The Commissioners Court also considers how much should be spent on infrastructure development, like the construction of flood control and wastewater projects and roads and transportation systems. The Commissioner Court also determines how much should be spent on parks and on economic development and many other things. Additionally, the Commissioners Court must determine is the salaries to be paid to county elected officials. This includes elected officials like sheriff, who supervise over 1,000 employees, as well as district and county attorneys. The district and county clerks, who each supervise over 100 employees, and smaller offices like the constables and the justice of the peace, which may only supervise less than 10 employees. Texas law provides that the Commissioners Court follows certain procedures when setting the salaries for these elected officials. The Commissioners Court must make an initial determination of the salaries to be paid to elected officials, providing notice to each elected officials of the amount of salary determined by the Commissioners Court. If there are no objections, the amount then become the salaries for elected officials. However, if an elected official objects to the proposed salary, that elected official has the right to present a request for a higher salary at a public hearing before the Salary Grievance Committee. That is what we are about to do this morning. Conduct a public hearing at which Judge John Chapman and his representative will present his request for a larger salary. The county attorney will present the county's position. I want to emphasize that this is a public hearing and not a trial. Really, this is really important, okay, very important. I want to emphasize that this is a public hearing and not a trial. There will not be testimony from witnesses or cross-examination. As members of the committee, you'll be allowed to ask questions of the participants and then deliberate on what you believe should be the salary. At the conclusion, you will be asked to complete the ballot before you that gives three options. Approve the salary as determined by Commissioners Court. So that's number one. It's approve the salary as determined by Commissioners Court. Second, approve the salary requested by Judge Chapman. So the second one is approve the salary requested by Judge Chapman, or propose a different salary for Judge Chapman. Each side will have 20 minutes to present this argument, 5 minutes for rebuttal arguments, 10 to 15 minutes for questions for committee members, and 5 minutes each for closing statements. After closing statements, the committee will deliberate and then vote. If 6 or more members vote to recommend an increase in salary, the committee shall submit the recommendation to the Commissioners Court. If 6 to 8 members vote to recommend an increase, then the Commissioners Court shall consider the recommendation at its next meeting. If all 9 members of the Salary Grievance Committee vote to recommend the increase and sign the recommendation, then the Commissioners Court shall include the increase in their budget. Are there any questions at this time? Anything that you would like for me to read or emphasize at this time?
No.
No, okay. So hearing none. So before I turn it over to Judge Chapman and his attorneys, let me offer this background. This year, the Commissioner Court took unanimous action to set the salary of Judge Chapman, Justice of the Peace Precinct 5, to a salary of $88,916.47. Judge Chapman has requested that his salary be increased to $101,247.38, which is the amount to be paid to other justices of the peace for El Paso County. The reason that Judge Chapman currently earns less than the other justices of the peace is that the last year the Commissioners Court lowered his salary based on the court's determination that the judge engaged in poor employment management practices that unreasonably exposed the county to potential liability. The reason the Commissioners Court has declined to increase his salary this year is because, again, the court has determined that the judge continues to engage in poor employment management practices that unreasonably expose the county to liability. Your role here today is to consider and decide whether to grant Judge Chapman's request for a salary increase. After closing statements, the committee will begin deliberation. Provided at the time of deliberation will be a ballot in which you are to sign. Further explanation on the ballot will be provided when both parties have finished their arguments. After you have finished deliberating and marking your ballots, we will record your votes. At this point, we'll go ahead and get started. So Judge Chapman or Mr. Howard, you may begin.
Judge, can I remove my mask?
Yes,
while
sir.
I'm
Yes, sir.
talking?
Yeah, because it's really important that they,
I don't want anybody to be deprived of the great opportunity to see my beautiful face. I've only got 20 minutes to address you this morning, and so I'm not watching the ball game on my phone. I'm watching the clock. My name's Jerry Howard. I am a board-certified labor and employment lawyer. Been board certified for over 10 years, been practicing in employment law in El Paso for almost 20 years. Generally, I represent the management side. Usually I'd be on the other side of a case like this, but I'm compelled to be here to represent Judge Chapman for the reasons that I'll explain to you here soon. But first I want to introduce Judge John Chapman. Judge Chapman is the Justice of the Peace for Precinct 5 down in Socorro. Can the tech guys put up my PDFs, please? Yes, please sit down. Okay, so we're here today, as Judge Samaniego said, because the county commissioners decided that Judge Chapman should be paid less than all the other JPs in the county. Judge Samaniego made reference to a similar decision that was made last year, and I'd like to just kind of complete the record for you. We went through this process last year. 7 of the 9 members of the committee last year voted to increase Judge Chapman's salary up to where it should have been with the rest of the JPs. The other 2 members voted to increase it only half that much, and so that's what the Council of Judges did. I mean, the Commissioners Court did. So you have that perspective in where these numbers come from. The difference here is $12,330. It's almost a 9% difference. And your job today here is to scrutinize the reasons why the commissioners did this to Judge Chapman. And at the end of this, we're going to ask you to tell the commissioners unanimously to pay Judge Chapman the same amount that every other JP in this county is being paid. And I'll also mention, and correct me if I'm wrong, I think the vote on this was 4-1 during Commissioners Court. I believe Commissioner Stout voted against the cutting Judge Chapman's pay.
I don't recall, Mr. Howard, we can certainly look that up, and I'll let you know
Please.
at the end.
Yeah, please.
All right. JP is a Justice of the Peace. That's what we're going to call Judge Chapman. There's 8 JPs in the county, including Judge Chapman. Judge Chapman is the only African-American JP in this county. He's also the only JP in this county who has a pending discrimination charge against the county. And he's the only JP in this county that's going to get paid a whole heck of a lot less than the rest. We're talking about personnel management decisions here, as Judge Samaniego mentioned. And let me tell you that Texas courts have made it very clear that although county commissioners set salaries for JPs, they're not supposed to get involved in personnel decisions and day-to-day personnel issues in a JP court. The Commissioners Court has a duty under Texas law to establish salaries, and Texas Supreme Court has made it clear that the salaries must be reasonable. This is not reasonable. The accountability policy is what this is based on. Can you move to the next slide, please? The county has an administrative accountability policy, and it says that it's here to ensure abidance with legally accepted standards and policies regarding employment-related matters. Move it up, please. It is not the intent of the policy to second-guess or supervise the employment decisions of elected officials like Judge Chapman. It is only directed at decisions that are arbitrary and capricious, taken in deliberate and intentional disregard of the law or policy, and which result in potential financial loss or employment accommodation, not sure what that means, to the county. Last part says that if the official exposes the county to unreasonable expense or loss, then they may result in a financial reduction to the budget. Now, next slide. A couple of key terms, and I'm not going to read these to you, but here's what arbitrary, capricious, and deliberate mean if you're not familiar with those terms, which I'm sure most of you are. Intentional is key because it means that it's done with intention or purpose to do some kind of harm. Keep those thoughts in mind. Please go to the next slide. Here's what the county, this is a letter we received from Mr. Sosa on behalf of the county attorney that says these are the 3 things that the Commissioners Court based their decision on to pay Judge Chapman less than everybody else. Allowing staff to work overtime, terminating an employee without prior notice, to the employee of performance issues and imposing arbitrary workplace rules. I'm going to go through each of these here in a minute. This letter, go down a little bit farther. I apologize, it's not on there, but the letter also says that the county commissioners considered these issues in 4 different meetings on June 17th, August 11th, and August 23rd in executive session. Judge Chapman was never notified or invited to the first 2 meetings, never told he was going to be talked about, and wasn't able to be present for that reason. Judge Chapman was invited to the August 23rd meeting, and he appeared at that meeting. Got a tiny little ledge here, and my stuff is rolling off. The only issue raised at that August 23rd meeting was FLSA, alleged FLSA violations. FLSA is a federal law that governs pay and overtime. And the allegation was that the judge had failed to properly pay a couple of employees. We'll get to that in a minute. The idea of terminating somebody or allowing staff, not allowing staff, but imposing arbitrary workplace rules was not discussed at that meeting, not with Judge Chapman present anyway. Now, I want to go through these issues, but I want to go through them backwards from the way that the county has put them into this letter. So I want to talk about arbitrary workplace rules first. In this letter, it's discussed that people are told which bathroom to use. To understand this, you got to understand that there are 2 bathrooms at JP5. Each bathroom has 1 toilet. One of the bathrooms is in the restricted area. The other bathroom, you have to pass through the public area to get to it. During the COVID pandemic, Judge Chapman made the decision that he didn't want the employees passing through the public area to expose themselves potentially to the public or other people. Okay? That's the reason. That's not arbitrary, capricious, or anything. That's an action taken to help protect his employees. Not on this paper, but another arbitrary workplace rule that one of the employees down there complained of is that they were locked in the building and the judge had locked the doors and they couldn't get out in an emergency. Well, if you go down there, you'll see how ridiculous that is because every exit door in that building has a crash bar on it. An emergency escape, push bar, just like on every other door. That's the kind of arbitrary workplace rules Judge Chapman's being accused of in this process. It's ridiculous. The issues aren't even worth the breath to address, but there's nothing wrong with the rules, and they don't expose the county to any liability. And so they're not violations of the administrative accountability policy. The next issue is that the judge terminated an employee.
10 minutes.
He terminated his employee, I'll call him Mr. V, for performance. When Judge Chapman terminated Mr. V said, "I don't care, I don't need this job, go ahead and fire me, I don't care." Or something to that effect. The employee is at will. He can be terminated anytime the employer wants to terminate him, or he can walk out whenever he wants to. Okay? There's nothing unlawful about terminating an employee. The employee had civil service grievance rights, chose not to execute them. For that reason, he can't file a lawsuit. There is no liability to the county based on the termination of this employee. So this cannot possibly be an Administrative Accountability Act violation. Now, the other thing I want you to keep in mind is the county says, well, you fired him without talking to him first. and you didn't give him a chance to improve, and you didn't do that. Well, no, first of all, he was spoken to often by Judge Chapman. And he was told, your performance isn't doing as well as it should have been. You should be doing this. The guy didn't do it. X, Y, and Z. Is it documented? No. Does it have to be? No. The Attorney General of Texas has said that the commissioners' courts have the authority to set salaries but not delve into decisions about who works for the elected official. And that's essentially what this is. This elected official has the authority to decide who's going to work for him and who's not going to work for him, as long as it's not an unlawful reason for terminating the employee. And I'm going to read to you from Texas Supreme Court Chief Justice Hickman. In 1939, he knew this already. He said, a public policy is thereby manifested in case of county and precinct officers generally to empower such officers to select their deputies or assistants and to forbid the commissioner's court or any member thereof from attempting to influence such officers in their selection of assistants. Cut the man's salary. Will that get somebody's attention? Will that influence somebody's decision about his employees? Would it influence you? The justice went on and said the reason for this policy is obvious. Officers elected to discharge public trust and upon whom the responsibility for the proper discharge thereof rests should be free to select persons of their own choice to assist them in its discharge. In other words, he gets to decide who he's going to employ, not the commissioner's court. And the commissioner's court has no business trying to influence those decisions by cutting his salary. Now we get into the more difficult topic, and that's failure to pay overtime. There's two employees here, Mr. V, who was terminated, and Mr. B. Now, prior to meeting with the Commissioner's Court on August 23rd, Judge Chapman got an email complaint from Mr. B on June 28th. Next page, please. Sorry. Can I get the next page, please? All right, there's the email at the bottom. He says he wants to be compensated for time where he was told to come in early, those types of things. Now, this is June 28th. The man's been there for 6 months or more, I think, at that point in time. Now, if you push it up a little bit. Now, if you see these blacked out marks, I'm blacking those things out because it's got people's names on them. Names aren't important to you, okay? It's Mr. B is the name that's blacked out here. So if you'll scroll it back up, please. Keep going, please. Next day, judge sends it to the county attorney and to county HR saying he doesn't agree with this and he's willing to discuss it, needs his input and recommendation. Next slide, or next page. Now, keep in mind, county policy says that an employee may not work overtime without prior permission from the supervisor. Mr. B had worked allegedly all kinds of overtime without permission from Judge Chapman. So Judge Chapman had an issue, didn't know whether they had to pay him or not. That's the guidance he was looking for. And so Human Resources asked him these questions.
5 minutes.
Move it up, please. Keep going. Next page. And those are essentially questions about whether he told him to come to work early, did he tell him to do training off duty, and those kinds of things. Here's the answers. Essentially, no, I didn't tell him to train off duty. No, I didn't tell him he had to come in. And he did not have, and Judge Chapman had no knowledge of Mr. B having done these things. Ultimately, next page. Ultimately, the county went through, came up with some data, and decided that Mr. B was due some additional number of comp time hours. Now, in government service, instead of being paid time and a half for overtime, the government agency can award compensatory time off, in other words, instead of paying you the extra time. So county auditor says, yeah, he's due some comp time, and look at why. Time worked was not properly recorded by the employee. Additional time not recorded by the employee. Go down, please. And Mr. B agrees. Okay? In the meantime, Mr. V was terminated. This is in mid to late August. In the meantime, on July 14th, Mr. V was terminated. And this is the same guy that was terminated that's the subject of these alleged poor personnel practices. During an exit interview, Mr. V told the HR department that he also wasn't paid proper overtime. Ultimately, the county went through the same process and presumably developed a similar determination here. We haven't seen it, and it's not in the investigation that I'm going to talk about here in a few minutes. But he also was awarded additional comp time and was paid for it on his way out the door. Now, unbeknownst to us, Judge Chapman, me, there was an investigation done in the middle of August by Ms. Natalia Chaparro. Ms. Chaparro is a human resources manager for the county, and she was assigned to look into these unpaid work time allegations. 11-page report with 13 exhibits. That's it. Ms. Chaparro concluded that Judge Chapman had violated the Fair Labor Standards Act by requiring off-duty training, off-duty phone calls, and reporting to work early. Ms. Chaparro never interviewed Judge Chapman. She interviewed the two complainants and one other witness. She did not interview Judge Chapman, nor did she ever go over the investigation results with Judge Chapman to get his input on any of this. In fact, we didn't even know about the investigation until late last week because we requested documents from the county to prepare for this hearing, and that's when we got it. In the investigation, she talks to both.
1 minute.
Judge, may I have maybe about 4 extra minutes, please, to finish? It's important that the committee understands
Is it my privilege to?
the content here.
Eddie? Yes, okay.
And I'll move through this as fast as I can. And ladies and gentlemen, I apologize because this is a lot to absorb. This is stuff that went on over periods of weeks and months, and we're asking you to get it all in 20 minutes. So when you do get your question and answer period, please ask those questions. In the investigation are Mr. V's phone records that he uses to claim that he was called constantly and required to call in constantly over the weekend by Judge Chapman. All there is a telephone list of dates and times. That's me. I'm now supposed to be quiet, but I'm not going to. So when you look at the phone records, it looks like there's a bunch of phone calls. And then Mr. V gives a bunch of explanations about all this. What Mr. V didn't tell Ms. Chaparro, apparently, is that Mr. V and Judge Chapman had been friends for a long time before he ever went to work for Judge Chapman. They met at a Walgreens where Mr. V was a manager, and they got to know each other, and they talked all the time. They socialized. They talked on the phone about healthcare issues and medicine issues and that type of stuff. You cannot tell from these phone records what these two talked about. This relationship continued after the employment relationship began. And they continued to talk on the phone about these kinds of things. Most of the calls that are after-hours calls were personal social calls that had nothing to do with work. Now, keep in mind, Mr. V is making these allegations against the judge within a few weeks after the judge terminated his employment. See any motive there? And the work-related calls were short. And the courts have said that de minimis work after hours is not compensable under the Fair Labor Standards Act. In other words, if I call Mr. Moore on Saturday and I have a 3-minute conversation with him and say, hey, don't forget on Monday morning you need to be here. That's not compensable. It's de minimis. It's not a Fair Labor Standards Act violation. And so there's no evidence in here that any of these calls between Judge Chapman and Mr. V anyway violated the Fair Labor Standards Act. Off-duty training. Mr. V submitted records. He said, I had all these off-duty trainings. There are a total of 2 credit hours that appear to have been achieved on a Saturday or a Sunday. All the other credit hours were on calendar days that were duty days. Now, we don't know what time most of them were because there's no time on the sheet that was turned in to demonstrate the hours, except for one seminar, and that seminar was all conducted during duty hours on a duty day. Judge Chapman told the county, can we add the next page, please? Told the county in his email response earlier that he had no idea that anybody was doing off-duty, let's go to the next page, please. That anybody was doing any off-duty training. And the Texas Supreme Court has, not the Texas Supreme Court, the United States Supreme Court has said that under the Fair Labor Standards Act, there is no violation of the act for not paying somebody for working when the employer didn't know they worked. All right? Judge Chapman didn't know that these guys were supposedly doing these trainings after hours. They never claimed it until 2 months ago. And they didn't put the time into their timekeeping records, or at least Mr. B didn't. Interestingly, Mr. V had accrued over 90 hours of comp time in his 6 months of employment and was called on it by the county HR manager, which tells you that he knew exactly how to put that time into his timekeeping system. He just didn't do it. And so you can't turn around, you can't award the time and then turn around and say he didn't give me the money because he didn't know. That's not an FLSA violation. He still gets paid for the time, but he is not a violator. Phone records. Here's the phone records that Mr. B turned in and said he made me talk to him after duty hours. It's not a phone record. That's a log that Mr. B created after the fact and there are no phone records for Mr. B in the investigation package. Finally, early reporting, and I'll cut to the chase on this one, is that Mr. B claims, let me have the next page. Mr. B claims that he was told to come into work early every day, which judge denies. Judge told several of these employees, if you want to come into the building early, you can. The reason they requested that was because several of them said, if I do that, I can get here a lot quicker and avoid a lot of traffic snarls.
Time.
All right? So nobody would have known that without talking to Judge Chapman. Scroll down.
Mr. Howard, your time is up.
Let me
It's
just
time, 5 minutes are up.
Let me make this one more point, Judge, if I may. Keep going. Here's just one example. where Mr. B claims that he's owed an extra 12 minutes because he came in at 7:48, 12 minutes before 8 o'clock. But if you look at the log out time for the same day, he left at 1:04. He only worked about 6 hours and 6 minutes. You don't get to claim overtime unless you work overtime. Now, not sure exactly how that all worked out, how he calculated that, but we don't know because the judge didn't have the chance to review these allegations in detail. The county did send Judge Chapman the records that they sent to the auditor to determine the underpayments. Judge Chapman said, okay, I have nothing else. Now, let me go, can you go to the very last page?
Time, Judge,
Yeah.
do you want to grant additional time, or do we need to stop now?
No, I need to stop now. Good.
There will be an opportunity for rebuttal, an
Yes,
additional
there
5
will
minutes
be. And-
after the county's position,
And
Judge.
they can ask questions as well, right?
Yes, sir.
So that might lead into your opportunity.
Thank you, Judge. I appreciate your indulgence.
Thank you.
Cover my face back up now.
Good afternoon, members of the committee. Excuse me. My name is Eddie Sosa. I'm employed as an attorney with the County Attorney's Office. My title is First Assistant, and my job consists primarily of overseeing the operations of the County Attorney's Office. We advise the county, we advise University Medical Center, formerly known as Thomason Hospital. We also advise Emergence Health Network, the local mental health authority. Personally, I generally provide advice to the Commissioner's Court on business transactions. I'm not one of their trial attorneys or litigation attorneys. That may become obvious here in a few minutes. But nonetheless, I've been asked to represent the county in this proceeding and try to explain to you the reasons for the decision of the Commissioner's Court to deny the increase that's been requested by Judge Chapman, and ultimately to ask you to mark that ballot as approving the decision of the Commissioner's Court. I will try to be brief. At the outset, I want to say that none of my comments are intended to be disrespectful in any way to Judge Chapman. At the same time, the judge has requested this proceeding, which is a public hearing, so I necessarily am going to have to go into some information in a public manner to discuss the reasons for this decision.
Eddie, to be clear, when you say judge, that you refer to Judge Chapman?
Judge
not
Chapman,
myself.
yes.
Okay.
So let's get to it. The reason for not increasing the judge's salary is that the judge continues to engage in poor employment management practices which unreasonably expose the county to potential liability. And when I say the county, and potential liability, what we're talking about is financial liability that is imposed against the county, which really is against the county taxpayers who fund the operations of the county. As has already been touched upon, first and foremost, the judge has failed to effectively communicate and enforce rules regarding overtime work. The judge, like all other managers in the county, has a responsibility to ensure that his staff understand that they are not authorized to work beyond the normal 40 hours a week without permission. At the same time, he has a responsibility to ensure that if they do in fact work those hours, that they're paid overtime in compliance with the Fair Labor Standards Act. You know, the law provides that an employer, may not knowingly allow someone to work overtime and then deny payment for that overtime on the theory that, well, the person did not ask my permission ahead of time. If the judge was aware, and I'm referring to Judge Chapman, that the individuals were working overtime, whether they requested permission for it or not, the judge is responsible and the county is responsible to make sure that they get paid for that overtime. In this case, as again has been already mentioned, we have one of their employees, one of the employees of Judge Chapman's office submitted a claim for overtime worked for an extended period of time, not a tremendous amount of time, not a tremendous amount of money involved, but he did submit the claim, claiming that he worked taking training modules, and that this was done in full view of the judge and with the judge's knowledge. Now, the judge denies this, but this has been corroborated by coworker statements and is consistent with the records and the IT documentation that has been reviewed. The county HR department assigned one of its human resources managers, as you've already been told, to conduct that investigation, which was conducted this last summer. A number of individuals were interviewed, documentation was reviewed. Communications from the judge in which he had indicated that he did not specifically authorize this work, and in which he claimed that he was not aware that the overtime work was taking place, were reviewed and taken into consideration as well. But the evidence from the other coworkers and the documentation was such that the conclusion was the overtime had been worked, the judge had knowledge of it, and that payment of that overtime in the form of comp time, compensatory time for the individual who is still employed with the county, and in the form of a payout for the other individual that got terminated. The report identified three main areas of overtime work. Work performed when the employee arrived early and was sitting there in plain view of the judge, going through training modules over a period of 5 months. The second area was instances where the judge contacted employees while they were off duty. Again, these individuals are not salaried individuals. These are hourly workers. If you're going to be called on weekends and holidays and expected to respond to the judge, you're entitled to be compensated for that. And the third area was completion of training hours while they were at home. Again, as mentioned, the records indicate these things were done, or at least in a couple of instances, were done after hours or on non-working days. Mr. Howard displayed the report. I think the only point there is to confirm that an HR professional did the investigation, did the review, and came up with their conclusions. And that was presented to Commissioner's Court, or reported to the Commissioner's Court, and it was one of the factors that they considered in making the decision as to whether to grant an increase in compensation to Judge Chapman. Okay. Now, as mentioned, the county went forward and paid compensation to these individuals. And why is that? Well, if liability is found, it is, again, liability against the county. You know, it's one thing if you have your own private business and you decide to run it a certain way, and you decide to deny overtime pay. Well, then if there's consequences for that, that comes against you personally. It's another thing when you're working in the public sector like the county. If liability is found against the county, that does not come out of Judge Chapman's pocket. That comes out of the taxpayer's pocket. And for that reason, you know, the county monitors this stuff and felt in this particular circumstance that it was compelled to make the payments to these individuals to avoid additional claims that could arise for failure to make those claims. And under the Fair Labor Standards Act, there is a potential for additional penalties and fines if an employer knowingly fails to make these payments. That's what the county was trying to avoid. That's the unreasonable exposure to liability that has resulted from Judge Chapman's conduct. Now, the second major reason for the decision not to grant a raise was this termination of the individual I think referred to as Mr. V. Again, this is a poor employment practice, contrary to the county's practices, to simply terminate somebody without prior warning of deficiencies in their performance. That's what happened in this situation. And when we say prior warnings, we are talking about written, documented warnings. You know, we believe that any of the employees in the county are entitled to a fair shake. If you're not performing well, you're entitled to be notified of it, given an opportunity to correct your behavior. And if that doesn't work out, then you may be subject to disciplinary action, including termination. But the situation is not that you should just show up to work one day and be told to report to HR, and then have some HR individual tell you, we've been notified by the judge that today's your last day, you're terminated, and we don't know the reason why. That's not how we want county employees to be treated. And terminations under those kinds of circumstances, in our experience, again, create exposure to liability. People tend to feel wronged and want to file lawsuits and actions in response to that. And more generally, are just wondering, well, what was the real reason for my termination? That's a second reason that the Commissioners Court considered in denying the request for an increase. Yeah, you know, there are other issues with the judge's management. Complaints that he has cameras installed in his office and constantly monitors staff. That he complains about the bathroom situation requiring all individuals, male and female, to use a single bathroom when there are other bathrooms available. The security issue maybe is a justification, but knowing the circumstances as we do, is not merited. But I'm not going to go into all of those. I think the two items that we have mentioned, failure to manage the overtime and the termination processes without any prior warning, are sufficient reasons for the Commissioners Court to deny a request for an increase. I want to point out that the county has actually gone through extra efforts to assist the judge. Last year, the county hired a personnel or performance coach to work directly with the judge to help him improve his personnel management practices. What was the result of that? Well, the contract was never completed. About November 20, around that time last year, the coach reported back that while there had been initially some promise and optimism about improving relations there in his office, that at the end, the judge stopped communicating, and the contract was terminated early with additional counseling sessions still available, at least one counseling session. I will read from the final notes from that coach. Although in the beginning, the judge displayed a genuine interest in wanting to improve the environment, communication, and general employee concerns as time progressed, there was a perceived feeling that the interest to improve was becoming less and less over time. Calls continued with the same focus, and takeaways were discussed at the end of the session. Although the judge was very open to have staff share their general concerns with me, after meeting with staff, it became more difficult to try to schedule new calls with the judge or staff members. Overall general interest to improve departmental challenges showed promise, but over time, many of the proposed changes that were discussed seem not to have been executed to help improve overall employee morale and communication. The county has made an effort to work with the judge and will continue to work with the judge. We want to have a successful office out there, but there are issues, and those issues are the reason for the lack of the pay increase. I've got one more item I'd like to do. I don't think this will show well on the screen, so we'll just give you a copy yourself. What you have before you is an exhibit I put together, to help me try to understand the dynamics in the office. And what you have here is you have a listing of the 6 positions that the judge supervises. It's not a large office. And if you look left to right, you see essentially the history of each of those positions. So let's just walk through it. The first position is court coordinator. In August of 20, an individual, I'll just go with their initials, MG, had been hired. If you look to the right there, by November of 20, MG was terminated for job abandonment. No complaint there, that's just what happened. In January of 21, HV was hired. This is the Mr. V that's been talked about. You look to the right there, in July of 21, 7 months later, 6 months later, HV was terminated without prior warning. And during his exit interview, not a few weeks later, but the same day that he went in for his visit with HR, he indicates that he'd been working overtime. Now, what's the current status of that position? Our HR department has worked very diligently with the judge to
5 minutes.
try to fill that position. And I believe as of September, you have a new hire judge filling that position. Okay. No,
No, yeah.
I had surgery on both my knees. I just want
Oh, no, absolutely. No, absolutely, sir.
I hear you. If we go to the next position, administrative specialist senior, an individual with the initials EM was hired. Look to the right, by March 21st, EM was terminated. Thereafter, an individual RG was hired in June, and of August 21st, RG has resigned. I believe that position is vacant at this time. Next row is court clerk intermediate. An individual by the initials YR has been working there for several years, 7 years, and continues to work there. Next row is court clerk intermediate SS, incumbent since February of 20. By December of 20, resigned. A new individual, JQ, was hired in January of 21. August 21st, JQ resigns. Again, I think HR has worked with the judge and been able to get a new person in there in September. Next row, court clerk intermediate. The incumbent retired in November 20. AB, which is the other individual, Mr. B, who claimed for the overtime, was hired in December of 20. June of 21, he submits his claim for overtime. July 21st, claims he's been retaliated against for his overtime pay. In August, he was placed on administrative leave, and at that time, the judge was attempting to terminate him. He currently remains on administrative leave. Then the last row is LG was working there in August 20, retired in January of 21st. An individual named RA was hired and continues to work there. For folks who have managed a place, that's a lot of turnover for a very small staff. And I think it speaks loudly as to the situation in the judge's office. And we think they're directly related to just overall poor management practices. And these are legitimate and sufficient reasons for the Commissioner's Court to elect not to give a raise. And we would ask this committee to approve that decision of the Commissioner's Court. And when you make your decision here, go ahead and mark that ballot, says approve the Commissioner's Court decision to leave his salary at approximately $88,000. And I want to point out that the Commissioner's Court action this year did not lower his salary. It's simply maintaining it at what it currently is. And the Commissioner's Court has directed the HR and administration to continue to work with the judge, but under these circumstances does not feel it's justified or warranted to give an increase. And we'd ask you to approve that decision. Thank you.
Thank you, Mr. Sosa.
At this time, there's an opportunity for rebuttal, so if Mr. Howard would like to go now.
Go
and
ahead,
it's at
Mr.
5
Howard.
minutes.
It's 5 minutes?
Yes, sir.
Can you all bring up that last page from the PDFs? Now just put the whole thing up there, please. So this is apparently what the county commissioners were told by somebody on a county staff. Judge did not provide anything contrary to HR and stated he did not agree. Judge didn't have a chance. But he did. You saw the email earlier where he said, no, I didn't tell him to do that. I also have an email here from June 3rd of 2020 from Judge Chapman to his staff. It says, beneficial to the court that the clerks take training, whatever training they need, pre-plan this training so that we can better serve the community. Schedule training in a manner that it does not admit the courts, does not affect the court's services. Training cannot be at the same time so that we've got somebody there to serve the public. It doesn't say, and there is nowhere, anywhere in any document from anybody where the judge said, do training on your own time and I'm not going to pay you for it. The only people that say that are the two people that are the complainants for the overtime. And that's where the corroboration comes from is, the two thieves pointing their fingers at the innocent. Judge Chapman never denied these people payment once he knew that they were due the payment. Make sure that's clear in your mind. He never denied anybody any pay. He asked for questions. He didn't understand what the requirements were if they hadn't asked for permission. And so he asked the county attorney and the HR department. They said, you got to pay. It's fine. You got to pay. Okay? And nobody knowingly denied these two people overtime. The judge didn't knowingly deny that. And there's no evidence other than these two guys' complaints of that ever happening. As far as potential liability to the county from Mr. V, Mr. V was terminated and made his pay complaint in July. If he wanted to pursue liability against the county, he first had to file a civil service grievance. He didn't do that. The deadline for him to do that passed before the county commissioners ever made this decision on Judge Chapman's salary. And if he didn't do the civil service, he can't file the lawsuit. Bottom line, before this salary decision was made, liability for Mr. V for any of these FLSA allegations was foreclosed. It could not happen legally. I'm sorry. It just can't happen. Cameras in the courthouse were installed by the county. Common in county buildings, especially in places where you have high-profile people like judges coming to work every day. The judge doesn't sit there and watch the camera. I'm sorry, that just doesn't happen either. He didn't have time to do that. Extra efforts from...
1 minute.
Extra efforts from a coach. The reason that coach went down there was because Commissioner Robinson wanted to go down there himself last year and get involved in the management of that office. Strictly forbidden by the law. And so the judge said, okay, well, I don't want to poke anybody in the eye, but instead of doing that, let's get somebody else that's not a county commissioner to come down there. That's where this coach came from. And he did work with the coach. And regardless of all that, it doesn't matter to what you have to decide, because nobody in the county ever said, we're going to cut your salary because you didn't play ball with the coach. It's not in there. First time that's even come up. Same thing with this thing. This is this list of employees. Nowhere in there in any of this communication did they say, we're gonna cut your salary or refuse you any kind of a raise because you have more turnover than we like.
Time.
B, by the way, the guy who judge tried to fire was the subject of 2 complaints from coworkers about how rude, angry, mean, and uncooperative he is in the workplace. And it wasn't Judge Chapman that wanted to fire him, it was Judge Chapman's court coordinator that wanted to fire him, but he didn't get fired.
Mr. Howard, 1 minute, please.
Look, you can't ambush somebody with all of this kind of stuff, not give them the opportunity to respond to it, and then come around and say, well, we just don't like the way you're running your shop. It doesn't work that way. It's not allowed by Texas state law. And most of this stuff is not the reason the salary decision was made. This was a setup. It's not fair. Most of it's not true. It's wrong. And we're here to ask you to right that wrong, make it right, pay Judge Chapman the same thing that every other JP in this county is being paid. That's the only fair thing to do. So we'll ask you to make that mark on the ballot sheet. Thank you.
Thank you, Mr. Howard.
I'll be brief. Again, part of this process, as was mentioned earlier, included a number of meetings before the Commissioner's Court regarding this situation and what should be done with respect to the salary. This was not a new thing or a surprise. Obviously, Judge Chapman went through this process last year and I believe was aware that his salary would be under consideration again this year. As part of the Commissioner's Court's process, after a meeting in June, the Commissioner's Court directed 2 of its members to meet personally, privately with the judge and discuss the status, and that meeting took place. One of the subsequent meetings provided for the judge to have an opportunity to address the court in closed session regarding his salary, and that took place. So I think there's no ambush. These issues have been on the table and fairly handled. And so, again, my only concluding remarks is we'd ask you to approve the determination of the Commissioner's Court and deny the raise. Thank you.
Thank you, Mr. Sosa. Well, your opportunity now to ask questions and make sure if there's anything that needs to be clarified, and you can ask directly to Mr. Howard or to Mr. Sosa of any question that you feel will help you make the best determination. So are there anything that you would like to ask to clarify or?
Yes.
Yes, go ahead.
I have a question on the terminations. Do the employees know the steps of the terminations? Do they have a handbook that they are given when they're hired, or no? I'm just curious, like.
Yep, Mr. Sosa, go ahead.
The county has a number of employment policies governing termination processes and
Okay.
disciplinary processes.
And employees are aware of that,
Yes.
correct? All right, thank you.
Thank you. How long has the judge been a JP? Go ahead.
Thank you for the question.
The microphone, Judge, please, so that we can make sure it's on the record here.
Not very good in microphone, so I'll try to speak up if everybody can hear me and stay my distance. I was elected.
It's an open meeting, sir, so we need that.
I was elected in 2015. This is my second term as Justice of the Peace. I pride myself in going to other counties and learning from the best judges in the state of Texas. And I want to make sure that y'all understand that I was doing what I thought was best under the law.
Thank you, Judge. Any questions?
I have one question.
Yes, go ahead, please.
Why weren't you invited to the meetings?
Ma'am, I'd ask you to direct that question to Mr. Sosa.
And which meeting were you referring to, just to be clear?
I heard that you had 3 meetings, and the first 2, he did not attend because he was not invited. I would like to know why.
Thank you.
Correct. The way the county government operates is the Commissioners Court, when they meet, they have to meet in compliance with the Open Meetings Act. So there's an agenda that is posted ahead of time that states what the county is going to be, or what the commissioners are going to be meeting at. The initial meetings were posted as discussions about the accountability policy. The initial meeting was not necessarily solely about Judge Chapman. It was a meeting at which legal and the HR department are required to report to the commissioners of any instances of employment decisions by elected officials that may create exposure to liability. It's a confidential closed session, so the judge was not personally invited to attend that. When we did set it up, when we were specifically talking about the judge, he was invited to that meeting.
Thank you, Mr. Sosa.
I have a
Yes,
question.
Go ahead. Go ahead.
Oh, I'm sorry. I also want to know, just like, if he was taking all this training on the computer, was it authorized? Did he ask before? Or was he told you need this? Or did he take it upon himself to just take all these training sessions on his own?
From what I've read in the investigatory report, the judge definitely directed his staff, and particularly newly hired folks, to go through these trainings. They're available through an agency that supports justices of the peace and other judicial officials to provide training modules that people can do. So I think the answer is yes, he was directed to do it. I agree. I don't believe the judge told him, do it every morning before you get to work. But on the other hand, the individual was showing up early and sitting there doing it. Again, the reports indicate that, the speakers were on. Anyone who passed by could see and hear that the individual was attending the trainings.
Does that satisfy your question?
Yes,
Yes,
thank you.
okay.
Thank you.
Yes, Judge Chapman.
Ma'am, just to reassure you, the name of the organization is the Texas Justice Court Training Center. Each individual that comes into our Justice of the Peace office is given a registration to that program where that they can take any type of training that they need when they need it. As far as this individual, it was not scheduled with me. I was not there seeing him do the training. I just want you to know that I was told that he was coming to work early to beat the traffic. I'm in my office trying to deal with my COVID issues and opening up my court, not seeing what this person is doing. And on the cameras are not set on any individual. The cameras were put there by the Office of Court Administration from the state of Texas in order to better serve the court. So I just want to make sure that you all understand that.
Yes, sir.
Thank you.
Thank you.
Yes, ma'am. Go ahead.
I have a question. Were all the judges or just certain judges giving the regulations for the COVID situation, or did each judge have to basically make his own decisions for his own group? Yes.
On the COVID situation, it's up to the discretion of the judge. I'm to look out for, number one, the general public that may be coming into the court, number two, my staff, and number three, and which I consider most important, is myself. If anybody comes out with COVID, we're all affected. They were stating earlier about the employees not being there during the month of October. I had 5 different employees to get tested for COVID in the month of October. Each time they would go out, they would stay out 10 days, 10 to 14 days and be out of work. Therefore, it affected the whole court. My interest is to make sure that whoever goes to that court does not get affected by the COVID. Everybody was, temperature was taken and everybody's information was written down. Do you have a cough? Do you have a sneeze? Have you been in contact with anyone with COVID? That's the guidelines that I follow.
Thank you, Judge Chapman.
If I can just add, ma'am, everybody should understand that these courts are not all the same. Okay, the judge's building is out in Socorro. It's a single level. It's not like a building full of courthouses like this one. It's a single level that has the judge's court. It's got the constable's office, and then there's several other offices. And so a one-size-fits-all approach to managing the physical space in this pandemic condition would not work.
Thank you.
I do have a
You
question.
have another question?
No, he
Oh, I'm
has
sorry.
one
This
first.
way. Yeah, thank you.
I do have a question, and that is concerning the employee's status. As civil service, I worked for the Texas Workforce Commission for 30 years and retired from there. When I worked as an employee of the Texas Workforce Commission, I was working under the civil service exception to the FSLA overtime provisions. And so I was not subject to time and a half overtime. They were required to give me comp time. And Mr. Sosa, could you explain the difference between these employees and me?
I'm not sure there's a difference based on what you said. In other words, in the normal instance, an employee for the county who works overtime gets comp time as well. It's only upon separation that that individual actually got a payout. Now there are issues with how much comp time can be accrued, and that's another issue about managing comp time. If individuals accumulate a large balance of comp time and then are either unable or not allowed to actually use that comp time, and for people who don't know, the way you use your comp time is you basically don't show up to work and you report it as comp time. So if you're in a situation where your employer says, we're not going to give you the time to take leave to use your comp time, you end up just accumulating a larger and larger bank of comp that you don't get paid out until you resign.
My next question would be, what evidence can you present us that the judge here actually refused to pay? I don't see any evidence that it was properly logged.
Right. You know, we have situations where people do not log their time. That is something that they can be counseled on and disciplined for failing to do that, all right? But it doesn't take away the responsibility of the organization to pay or grant the comp time if that person in fact did the work. Now, the claim came late.
But
It should
do
have
we,
been
do we
claimed-
expect the judge to be psychic and be able to predict that ahead of time?
We don't expect them to be psychic and predict it ahead of time, but we do expect the judge to monitor, and we have statements from individuals that, yes, the judge was monitoring through the cameras or personally and was aware.
I have an additional question. This is concerning due process. When a person files for unemployment and the employee and the former employer disagree on what happened to cause the job separation, when we do a job separation investigation, even the most routine, we are required to do strict due process. And the Judge Chapman here has indicated, or his representative has indicated that he was not afforded due process during key aspects of this entire thing. In fact, there was a person who conducted an investigation into exactly that. And Mr. Chapman's representative here had said that he was not given due process in that investigation whatsoever. Is that correct?
No, we disagree with that. We think that he was given due process.
Can you give us evidence that he was given due process?
Yes, his information was reviewed. His emails containing his statements regarding the claims were reviewed and considered and referenced in the report.
Okay. So he says one thing and you say something else.
Well, that's necessarily how these situations go. You know, the
Well,
commissioner's
that's what
court
we're
has
going to have to
rely-
decide on.
All right, thank you.
Thank you, sir.
May I address that question also?
Sure.
The county's policies on investigations and the county attorney's office on investigations has stated very clearly that when an investigation is done, the investigation is to be reviewed with the person that's the subject of the investigation. That wasn't done. Not only was that not done, he wasn't even told there was an investigation going on, and he wasn't, the results of the investigation were not shared with him, nor was he given the option or the opportunity to respond to the results of the investigation. Thank you.
Any further questions?
Yeah, I have another
Go ahead.
question, if you don't mind.
No, absolutely.
Was he mandated to finish the coaching sessions, or was it voluntarily?
No, I don't believe there was any mandate. It was voluntary to participate in it, but it was made available to him.
Okay. That was my next question.
Just briefly, ma'am, on the question that you'd asked, I dealt with the person that was doing the coaching, and I really appreciated her, and I really appreciate speaking with her. At the end, what had happened is she had asked to schedule to meet with my staff. We went over that. It was supposed to be set up. We called the day before, and it was not set up. I called the staff, had them to meet with her. And after that, when the COVID hit in October, and if you look at the schedule that they provided for me, most of this was done in October. I had at least 5 employees out getting COVID tested in October. The COVID hit us like a ton of bricks, but mainly it was test after test after test after test. And each employee that got tested would be out from a duration from 7 to 10 to 14 days at a time. And it was one after the other. I wanted to make sure that you understood that I like my yellow. I just didn't, one last part. I went to HR and I told them I wanted to continue. They never authorized it. There was never an authorization to continue the coaching. And I went to them and I asked them. I've worked with them since the day I got here, but I just don't understand when these things come up, they kind of like put me in the back there. I've always worked with all of them, and I've enjoyed working with all of them. And I would like to see myself, although I'm here in front of this committee, I think I'm a fair person. I would not do anything that I would not ask anyone else to do.
Thank you, Judge Chapman. Any further questions? If not, Mr. Howard, for the closing comments?
I'll call my star witness, Judge.
I guess you all have had enough of me. I kind of made some notes, but, you know, being a judge and standing in front of this committee is 2 different things. Like I told you just a second ago, from the day I got here, day one, I've tried to work with the HR representatives. I've did everything that I could. I even called on the judge here. He came to my office and I told him, Judge, I need help. I called on Mr. Robinson. He patted me on the back and says, help is on its way. I called on Mr. Leon. Because I did not agree with my constable, he kind of slided away from me. I've counted on everybody within this county to please help me. I like working with people. I don't like training people over and over and over again. But if it's what I have to do, it's what I have to do. According to when I went to my training, they told me specifically, they said, Judge, you're gonna run into situations where what you're told to do or what you have to do is not very popular. And I guess in this case, it's not popular with my employees that I had to take the steps that I had to take. I knew Mr. Vidal from Walgreens a long time ago. I tried to hire him because of his management skills. But once he got into my court, I noticed a different person. I noticed it's like, it's either us or them. That's one of the things he told me. I don't need your job, he tells me. I got a job that paid me over $100,000, but I never really asked him and said, well, why did you leave that job? I trusted him. I would give him a right arm. We would go out to eat dinner together. I would call him about his kids. I would call him and ask him medical advice. I trusted him as a friend. To be honest with you, I was very hurt. But I didn't see no other way to do this. Let me give you an example. One of the things I deal with at the court is truancy issues. They had truancy issues set up in my court. Believe me, out of 5 years of being there in the court, one time I call in sick and say, hey, you know what? I gotta go to the dentist, I don't feel good. Can you please postpone the court cases until the following Monday? It was 2 months later, the court cases were not transferred. They just sat there. I barely heard them yesterday. So I had these kids and the schools waiting for me to do those cases, and they were not there. I would ask him, hey, where are the cases for that case? I don't know. But it's his responsibility to know. On one part, we have evictions. Evictions are important to a lot of people, especially to set somebody out into COVID. Where are the eviction cases? Oh, I don't know where she put them. I don't know where it is. Where it is. A stack of papers this tall, the eviction cases are coming up. They're at the very bottom of the stack. And I told him, Hector, did you see this? But nothing was never done. Grievance Committee, I can only tell you this. I don't enjoy being here. I'm a very humble person, and I'm a very proud coach in my community. My community elected me twice to be there to serve as their JP. There's others that don't want me to be there for their own personal reasons. But believe me, I have a staff right now, well, not a staff, I have a loaner from another court and a staff that I'm working on that's making the worlds of difference in my court. They're working with us day by day. And I think one of the ladies wrote a letter to HR to tell them what was going on in our court. It's the negativity. I don't have a chance to deal with each personal employee effort. That's what the managers are there for. That's what the court coordinator is there for. That's what the supervisor is there for. You know what I'm supposed to do, folks? I'm supposed to judge. I'm supposed to sit there and say whether he's right, or give my best opinion of that. A long time ago, HR told me, Judge, the court to your staff. So I do. And now here I am. I just want you all to understand that. I went through a lot of this, but I'm very proud of what I did. I just hope you as a committee can look through me and see that I'm a sincere, true person doing the very, very best like any other JP out there. I wouldn't tell you that I'm any better or any worse than any JP, but I don't think they're better or worse than me. They have more experience.
Time.
But I have a phone, and I call every judge within the state of Texas until I get the right answer. Thank you for your time.
Thank you, Judge Chapman. Mr. Sosa?
Again, good afternoon now. My only closing remark would be to, again, ask that you approve the decision of the Commissioners Court. I'd ask you to take a look at that chart. I mean, it does tell a tale there. We can agree that there are some employment issues in that office, and they need to be addressed. The county's ready and willing to continue to work with the judge on those matters. But with respect to salary, the situation is such as that an increase is not merited at this time. We'd ask you to approve that. Thank you.
Thank you.
Right, yes. Good afternoon, Judge. Good afternoon, Commissioners. Thank you for being here today. I know this was a volunteer opportunity, if you will, but it's really a public service for the county and what you're doing. So I know from Mr. Howard, and of course for Judge Chapman, and of course for the county and the county judge, that we really much appreciate you being here. My name's Christina Sanchez, and I serve as an assistant county attorney. I am here just to provide a little bit of guidance at what happens next and what is the decision. So you've heard from both sides. You've heard from Judge Chapman. You've heard from the county. Now before you should have, I'm going to go ahead and put this on the screen. Mr. Mendez, if you can.
Christina, I'm just going to read in item 4, okay?
Sorry.
No, it's okay. Item number 4, make findings and recommendations regarding salaries and personal expenses.
Yes, thank you. This is a sample ballot, but before you, each of you should have your own ballot with your name. If you can just check to make sure that your name is on that ballot. And so, as you can see, it's pretty self-explanatory here. We're just going to ask you to determine whether or not you agree that the salary would remain the same. That was set by the Commissioners Court at the $88,000. And again, I'm just giving the estimates here. Whether or not you agree that it should be the amount as requested by Judge Chapman, which is the 101. And there's also, of course, a third option if you want. You don't have to, of course, but whether or not you believe that a different amount should be allocated to Judge Chapman, if you will. So that's there for you all to decide. And I'm just going to go ahead and also put this up. I know
Ms.
it's-
Christina, could you please let them know that the second option is just like every other justice of the peace in the county, please?
I think they've heard the judge there. As he's mentioned before, the 101 is the same amount as is set by the remainder of the justices of the peace. So there you, just to clarify that, yes, Judge. Here is the actual statute that talks about the Salary Grievance Committee and what happens after you've had the opportunity to cast your ballot, if you will. And so I'm just going to read straight out of the statute, just so that we're all aware and for the public's benefit as well. If after the hearing, 6 or more of the members vote to recommend an increase in the officer's salary or personnel expenses, the committee shall submit its recommendation to the court in writing. That's the Commissioner's Court. If 6 to 8 members vote to recommend the increase, the Commissioner's Court shall consider the recommendation at its next meeting. If 9 members, which would be all of you, vote to recommend an increase and sign the recommendation, the Commissioner's Court shall include that increase in the budget before the budget is filed and the increase takes effect in the next budget year. So that's how this gets handled and considered by the Commissioner's Court. I'll pause here in case there's any questions with regards to the ballot process or what is being asked at this time. Does anybody have any questions? No? Okay, at this time then, if you all, I don't know if you've already done so, but this time you can also deliberate. And so what that means is you all can talk amongst yourselves as you reach a decision. You don't have to do that if you do not want to do that. If you want to just go ahead and vote, you can go ahead and do so. But you're invited to do that at this time if you wish to do so. We'll give you a couple of minutes, or if you need more time to do that deliberation. And then afterward, what we'll go ahead and do is I'll collect the ballots here and read them off. So we'll give you that time. Unless you all are already done, I'm not really.
Well, I just want to just say that it's difficult to deliberate, but I want somehow we could figure out if that's something you want to do. I know it's difficult under these conditions, but you're very welcome to talk amongst yourselves and, you know, whatever you need from each other.
Did everybody mark their ballot? Not trying to rush anybody, but I can't tell. Or do you have a question, or go ahead?
If
Go
we,
ahead, go ahead,
well, I'm just asking, if we deliberate, like, you know, he's way over there, and so we can,
A little privacy.
yeah, a little bit
Yeah,
hard,
it's kind of hard, so we just ask, I know the setup is not as comfortable, we're not in a round table, unfortunately, because of COVID, we're trying to make sure that the partitions and we cannot go into a separate room, this has to be in an open area, so I would just ask if you want to talk about it, just please talk loudly into your microphone, and then perhaps, look over, or of course, the judge is the mediator as well here, he's there, so if you want to just raise your hand and he could acknowledge the folks that may have some questions.
Thank
We, in 2020, we came into grand jury.
Mm-hmm.
And we spent 9 months, and I wonder if we could deliberate on, this issue, because we used to do it.
In private, is that what you're asking?
Yeah, right now.
Yeah, unfortunately, sir, this is not a grand jury deliberation. This is a salary grievance committee, which is governed by statute, and unfortunately, it's clear that there cannot be closed-door deliberations. In other words, where everybody gets out of the room and the committee is allowed to participate on its own. So it does have to be open.
Open meeting.
At this time. Yes, sir. Thank you for asking that question. Ready?
Yes, I'm just,
At this point, I am willing to discuss openly with anybody here. I will tell you, I've already made my decision. But as far as deliberating, we'll do the best we can,
thank you.
given the circumstances.
I think I myself have made my decision as well.
Okay.
I've already made my decision.
So is everyone comfortable with going forward and presenting your ballots?
Would you want us to explain the reason for our,
Sure, we could do that. If you all, we can handle it a couple of ways. I can collect them and read them out to the group. There's no set way. We just we're doing the best we can here with how we're doing it. Or each one of you can individually read it to say what your decision is for this particular matter.
Yeah, whatever
However
you
you would
feel.
like to handle that. If it's easier, I'm happy to collect the ballots.
You reading them is fine. for
Okay,
me.
all right. Does everybody else feel comfortable with that? Is that a consensus? Okay.
Okay.
I'll go ahead and collect them, and then I'll just come right straight to the podium.
Thank you, Christina.
Thank you.
I'm sorry, I'm trying
No
to
worries.
hurry.
I'm sorry. Yes, I'll go the other way. Thank you, sir. Thank you, ma'am.
I'm sorry.
No, you're fine. I'm sorry. Don't rush. What I'll do is I'll go ahead and just read it out in the open so that both parties are aware here. So we have one from Mr. Stephen J. Smith, and his vote was to approve the amount requested by Justice Chapman, which was the 101,247 and 38 cents. Second, Grievance Committee Member Patricia A. Moya has voted to grant the amount requested by Justice Chapman at $101,247,038. The third vote is from Mr. Ramon Siriza, and his vote was to grant the amount requested by Justice Chapman at $101,247 and 38 cents. We have another one from Ms. Monica H. Gonzalez. Her decision was to leave it at the amount set by the Commissioner's Court at $88,916.47. We have another vote here from Adrian Moore to set it at the amount requested by Justice Chapman at $101,247 and 38 cents. Germán A. Valenzuela has agreed to set it at the amount requested by Justice Chapman at $101,247 and 38 cents. Maribel Segura has agreed to set it at the amount requested by Justice Chapman at $101,247 and 38 cents. We have another vote here from Patricia Amezquita to set it at the amount as granted by Commissioners Court of the $88,916.47. And then the last vote was from Ms. Martha Holstead to grant the amount requested by Justice Chapman at the 101, 247 and 38 cents. So the final tally is the 7 have voted to grant the increase at the 101. We have 2 who have recommended to leave it at the 88 as set by the Commissioner's Court. And so what happens next is, per the statute, because 7 of you have voted to increase the salary to the 101, it goes back to the Commissioner's Court as a recommendation. It'll be discussed with the Commissioner's Court, and the Commissioner's Court will make the final determination at that time. And when, of course, we will present the votes from both the 101 and the 2 here. And so that's it, Judge. That's the end of the meeting at this
Well,
point.
once again, I do thank you for being here. Having, community participate is really important for us, and we'll take into consideration the vote, not specifically what was said, but the vote in itself. And we'll take it to Commissioner's Court, and then we'll vote again on there'll be a recommendation from the Grievance Committee. So thank you very much. I appreciate every one of you.
For the opportunity.
Thank you, Judge Chapman.
I'd like to take the opportunity to thank also the Grievance Committee for your time. Thank you for being here. Hopefully we'll see you all at
Thank you.
And just before everybody leaves, again, thank you so much for your time. If you need a work note, happy to provide it. And then also parking validations before you leave. Ms. Murguia is right there at the exit of
I do have the letters for each one of them on the, explaining that they were here.
I'm sorry?
I said I have their, a
Oh,
letter from
perfect,
each one
thank
of
you.
them.
The judge has those letters to excuse you from work if you need that. Thank you.
Thank you very much.
This concludes today's meeting at 1:06 PM.